My Lord, before this short adjournment, I was just identified the three main points on strength. The approach to strength, the strikability of the Higgins claim, and the procedural point. And what I'd like to do is to start with the approach to strength in a little more detail. I've shown you already what we say the approach to strength should be, based on Paterel. And what I'd like to do next is to show you how the tribunal approached strength. And if I could ask you to start by going, please, to page 278, where you'll see, this is of the bundle with the judgment. And you'll see that on this page is the quotation from the dissenting judgment of Lord Sales and Legate on the risks of class actions and the risks that speculative actions put pressure on defendants to settle. And the tribunal unpacks that and expands on the concerns of Lords Sales and Legate in relation to opt-out collective actions. Now, one sees how this is apparently potentially relevant if one looks at footnote 32, because what they say about this is this, in footnote 32, which is on page 279. They say, it might be said that in articulating this issue, we are expressing a prejudice or presumption against opt-out collective actions generally. That we do not consider to be correct. What we are here doing is articulating an attribute of opt-out collective actions that a court needs to be aware of. How this attribute is taken into account is a matter for later consideration. As we make clear later on in this judgment, this attribute is a matter that feeds into the strength criteria that is articulated in Rule 79.3a. So what the tribunal seems to be doing is to say that this danger, as it sees it, of undue settlement pressure is a matter that should be taken into account in the choice between opt-out and opt-in by feeding in a manner that isn't articulated there to the interpretation and application of the strength criteria. Now, I don't need to tell you that the judgment of Lord Sales and Lord Legate was, of course, dissenting on this point. Now, if we go forward to page 287 in the judgment, we see here from paragraphs 98 and following, this is now the tribunal's discussion of the strength of the claims factor as it sees it. Now, some of what is said in these paragraphs we take no objection to and is consistent with Paterel. That applies to the statement that strength doesn't involve an assessment of the merits in terms of prospects of success, which you see in paragraphs 98 and 100. We also accept that strength isn't simply surviving the strikeout test, that's paragraph 102, and we agree that the guide was not articulating a presumption against opt-out proceedings. They say that in paragraph 105. But there are certain statements in these paragraphs that go further than that, and they indicate an approach that is inconsistent with Paterel and wrong, and one that is wrongly informed by this concern about settlement pressure that they identify earlier in the judgment. Now, first, we see in paragraph 104 on page 289 the statement that the fact that class members have not signed up to give their support to a claim may suggest that the claims are weak, and the additional benefits of opt-out proceedings over and above opt-in proceedings ought not to be conferred for that reason. And what that seems to be suggesting is that, first of all, that opt-out is a benefit, presumably that's a reference back to the settlement leverage benefit, and it's one that has to be in some way earned. And it's also suggesting that a supposedly weak claim shouldn't typically have that benefit. That is not, with respect, the correct approach. And I've explained, I won't repeat myself, as to why. It's inconsistent with paragraph 107 of Paterel. Now, the tribunal then goes forward, if you turn over the page to page 290, and it refers to various other, what it calls analogous cases in the United Kingdom's procedural law that it thinks can assist it in clothing strength with better meaning. And it refers first in paragraph 110 to the NWL and Woods exception to American cyanamide, where you have a application for an interlocutory injunction, which is in fact going to be a final injunction to all intents and purposes, and there the courts are prepared to look at the strengths of the parties' cases to a certain extent. And they then go on in paragraph 112 to look at the good arguable case, better of the argument on the available evidence test for jurisdictional gateways. Now, we see that in paragraph 113 that the tribunal proposes to use that latter test as a guide, supposing that plausible is to be interpreted as something reasonable or probable. And the implication is that opt-out claims have typically to be likely to succeed, and if they don't, then that is a point against them being certified as opt-out. And we say that actually the tribunal was wrong to seek to transpose the approach to the merits taken in relation to final injunctions and jurisdictional gateways. And there's an important distinction here, because in both of those cases, there will be no final trial, no final and subsequent trial on the merits of the issues with which they are concerned. The whole point of the NWL and Woods exception is that it's one where the injunction is going to be final, so you're not going to have a trial. And in the jurisdictional gateway cases, the issues such as is somebody domiciled in the UK or is there an exclusive jurisdiction clause are very unusually anyway, don't arise again at trial. So the resolution is a final one that doesn't need to be revisited. And so they're not good comparators. And it's particularly invidious to be making an assessment of strength and of supposed weakness at an interlocutory stage when one knows that the same issue will be revisited at trial. And what makes matters worse is that the judgment then goes on to state at paragraphs 115 to 117 over the page, because what they say is it's not just the good arguable case test. What they seem to be saying is that, as you see in paragraph 115, it is probably a valuable exercise for the tribunal to consider the sort of evidence that would have to be adduced by the PCR in order for a claim to succeed, so as to enable the strength or the plausibility of the case as presently articulated to be gauged. So they're not just, they say it's not just an exercise in looking at the current articulation, you also have to try to predict whether they're going to get that evidence to prove it and what's the likelihood of that.
And we say on a summary judgment application.
You do.
Although the court's enjoined not to engage in the mini trial,
yes,
quite often the judge will assess what evidence and what disclosure is likely to emerge, and how that will affect the claim.
Well, that is true, but it is normally done in a negative sense, isn't it? In the sense that people say, well, we don't know what's going to emerge at trial, and therefore this isn't appropriate for summary judgment. What you don't do is positively say, well, you're never going to get that disclosure, are you? You know, that's never going to, because that's just not the right approach at an interlocutory stage. Now,
actually, I'm not sure that's right. Actually, in order to prevent your claim being struck out, you often say there is the prospect of obtaining a specified type of documents on disclosure. You can't just say something may turn up until the argument does turn, or can look quite specifically about whether a particular type of document will or will not become available on disclosure. So
I accept that, but I think, but I think I accept that too. I see that in those sort of circumstances, you can say, you know, that there is a realistic chance, but of a particular. You would, yes. In some cases, you have to, and I accept that. But I suppose the difference here is that what they are doing is they're taking the good arguable case test. They're saying, do you have the better of the argument on the basis of the material available? And then they're taking and they're expanding that, apparently, and saying, well, and we've also got to consider what the likelihood is And that seems to be indistinguishable from evaluating the prospects of success and the merits, it seems to me. What else is it doing if it's not doing that? And you're effectively saying, is it likely that you're going to succeed? Are you going to be able to prove your claim? And that seems to me to be the merits behind any other term. Now, what the tribunal does next is to embark, as you've seen, in part 6 of its judgment, entirely of its own motion, of a consideration of whether the claims were worthy of strikeout. And it does that notwithstanding the fact that, as it recognises later, it hasn't put either claimant on clear notice of the precise defects that it perceives render their claims demurrable. And the tribunal then goes on to find that the claims were worthy of strikeout, and they had not met the test of establishing that there were reasonable grounds for bringing the claims. And I'm going to have to come back to the basis of that. But if I could just show you the conclusion, it's at page 200, paragraph 240 on page 375. The judgment is here at this point in its judgment is at pains to assert it isn't making any determination on the merits. It says that it is concerned with how the case is pleaded, and one sees an example of that in footnote 152 that Lord Justice Green referred to. Its complaint is, they say, that the pleading is lacking in specificity. And it's at a too high a level of generality or abstraction. Now, what happens is that after having held here, that they have no doubt, they say in paragraph 240, that the test of reasonable grounds for making the claim is not met, and that both applications could be struck out. Having made that finding, they then forbear to go through with it. And you see the reasons why are articulated in paragraph 241 of the page on page 376. And you see again in 241.1, they say, we are in no doubt these applications could be struck out because as presently framed, we simply do not understand how they could be properly tried. They say the pleadings give no idea as to how the losses claimed have been suffered. So it's put very high there. But then in 241.2, they then explain why they don't go through with it. And the oddity is that, essentially, because they say we haven't given the applicants, as they put it, an opportunity to address the concerns, we have articulated much more clearly in this judgment than we did during the hearing. So they accept there that there has not been an opportunity on the part of the applicants to address our final thinking on the question of pleading. But then there's the most extraordinary twist, because then, notwithstanding that act of apparent forbearance, then when it comes to opt out, they use their trenchant conclusion that the claims are weak and strikeable as a basis for opt-out. And you see that if you go forward to page 431, and you see that they start with some points of statements of law which we don't dissent with, say in paragraphs, subparagraphs 1 and 2, say perhaps suggestion.
Paragraph?
So it is paragraph 374, my lord.
Yeah.
And they then they suggest that strength will be important. And I think we would caution that it will not, with Paterell, that it will not always be important. In fact, generally it possibly won't be important. But then in subparagraph 3, they say the strength factor as articulated in the legislation is not a factor that correlates strength with any particular outcome, But as a general rule, it seems to us that the weaker a case is, the less justification there is for certifying on an opt-out basis. So they see the role of strength on a scale, and they see it as if they see their role as looking at whether the claim is weak, and if it is weak, then you put it in the opt-out bucket. And we say that isn't consistent either with Merrick's, the spirit of Merrick's.
The opt-in bucket.
Forgive me, the opt-in bucket. Forgive me. And then if we then go back to the judgment at subparagraph 4, we see it says that a pleaded case can be strong or weak in one of two ways. They say it can be clearly and fully pleaded but intrinsically weak, or it can be weak or not strong because it lacks the necessary particularity to be evaluated. And then over the page we see paragraph 375. In the present case, the claims pleaded in the applications are so weak that they are liable to be struck out, although, for the reasons we have given, we haven't done so. Clearly, the claims pleaded in the applications are weak in the second of the two senses. That this lack of particularity makes it effectively impossible to gauge the strength of any case that might be made if they were to be pleaded more fully. And then they say they then conclude that they're weak in that the claims pleaded, you see in the last sentence, in the applications are weak in both of the senses we have used, and that this amounts, they say, to a powerful reason against certifying on an opt-out basis. And so that's why I do say, in particular in response to my Lord Justice Green's comments, that this is a basis for their decision. This is part of the ratio, and they say in terms that they are so weak that they are liable to be struck out, and they use that as
intrinsic and in pleading terms.
Yes, intrinsic and in pleading terms. We say that this embodies simply a wrong approach in law to strengthen claims. If I could then come on to the second error, which is the error in saying that Higgins' claim was liable, was so poorly pleaded effectively that it was liable to be struck out.
Can I just add perhaps a caveat in favour of the cat? It may not be. And conclude that the claims pleaded in the applications, so as presently pleaded, I know we come to the inconsistencies about what they then did, but as presently pleaded, if you like, before us, not necessarily as they might be pleaded in due course. Now, that raises all sorts of issues, but would that be a fair way to read that sentence? It's the pleading which is before us which we don't like, intrinsically or as a pleading.
Yes, but I think I'll need to find the precise reference, but they, earlier in the judgment, when they deal with strikability, they say, we think that this is all just too theoretical and high level, and these are vermin. We say this isn't a failure on the pleader's part, effectively. They say to translate theoretical theory into proper averments. It's more profound than that. They think it's effectively, it can't be pleaded. But they say, well, they hint that possibly there might be some specific disclosure application that you could make that might then enable you to plead.
No, they say that's a wing and a prayer.
But they say that's a wing and a prayer. But they don't really, the suggestion is there's basically no way of pleading this. Is really the cut and thrust of it.
Well, footnote 152, they fairly squarely do and seem to attribute the failures that they've identified to the pleading case.
Yes, although that
They
is, one
actually
needs to be a
say-
little cautious because 152 is a reference back to a particular part of the Evans pleading. So they are attributing that to defect. But as you can see in those paragraphs,
Yeah, I've got you.
Yeah.
Yeah, I follow.
Now, the core of the tribunal's reasoning in relation to the O'Higgins claim and why they say it's strikable is contained in paragraph 238 of the judgment. And what we have done is to prepare a document that identifies the particular criticisms and cross-refers to our response to those criticisms and to the evidence. We provided this yesterday morning to my learned friend, so he's not taken by surprise. If I may hand it up. And the reason for doing it this way is essentially so that you have the references in one place, and so that I don't have to spend too much time going through every single reference.
238 is actually quite a long paragraph.
It is, it is. Now, before I, tempting as it is, if you like, to jump into that and go through it, take you through it immediately, I think that it's going to be more helpful to the court and more digestible if I, first of all, if you like, pan out and make some points, more general points, about how the judgment approaches pleadings of these types generally, and also then takes you through some of our pleaded case. And I do it that way because, in particular, the way that the tribunal there's a very long section in the judgment. It's in section E of the judgment, which starts at page 333 and goes all the way through to page 363. It's paragraphs 197 to paragraph 234, in which it sets out its general reflections on pleading cases of market-wide harm. And in a sense, some of the error of approach in strikeout can be traced back to those more general paragraphs. And so it's important, I think, to pick up those errors, if I may, before I get into dive into the detail. So if I could go first to page 334 of the judgment, which is at paragraph 204. And to start with a statement that we agree with. What it says here is, a pleading must set out, but does not have to prove all the material facts on which a party relies for his or her claim or defence. And in footnote 104, they say, rightly, pleadings plead the material facts, not evidence and not law. They state an arguable case, they do not prove it. Now, that, of course, is an absolutely most fundamental proposition of pleading. Unfortunately, it is one that, in our respectful submission, the tribunal completely loses sight of later on. Now, one of the things that the tribunal refers to there is it talks about pleading or alleging all material facts. But it's important to remind ourselves of what is meant by a material fact in the context of a pleading, because a pleading certainly doesn't have to contain all the allegations of fact that a claimant subsequently relies on at trial. What it requires is all the necessary or essential facts, all the key facts that complete the cause of action. And of course, if it didn't do that, and it just went through every single fact, it would become a recitation of the evidence. And it's important in this regard that, as Lord Wolfe remarked in the judgment in Macphillimian Times newspapers, I'm sure you're all familiar with, that the need for extensive particulars has, to a large degree, gone with the advent of written witness statements. And that's why the CPR, in particular, it talks about a concise statement of the facts on which the claimant relies.
You try telling that to 95% of the pleaders of cases in the business and property court.
Indeed, well, indeed. But what is odd about this? What is odd about this judgment is that it goes in a completely the reverse direction, because it is, and they need to be very careful what you ask for, because if you say you haven't given every single last particular and therefore it should be struck out, it's a very dangerous route to go down for a tribunal. Now, Lord Wolfe's comments about witness statements, of course, particularly apposite in the context of the CAT and these types of collective action, because these types of claim start off with not just a pleading, but typically start off also with extensive expert evidence. And indeed, that was the case here. We had a claim form, but attached to the claim form was originally was the report of Professor Breeden, and then subsequently the report of Professor Burnham. And so the result is that when one is considering whether the averments have been made with proper and adequate particularity, in this sort of context, one has to consider not only the claim form in isolation, but also the accompanying expert evidence, which is often cross-referred to, and indeed was in this case. Now, the tribunal seems to partly recognize that in paragraphs 235, which you see on page 363, where it notes that often questions of strikeout can be considered by reference to the pleadings alone. That is not appropriate in the case of the present applications because of the considerable additional material adduced by the applicants, which material is in some cases specifically referenced by the applicants in their pleading. So one has to look at the claims in their totality, not just the claim form. And indeed it's desirable that claim forms should as a whole be concisely expressed and at a relatively high level, making the essential factual averments, but no more, and cross-referring to expert evidence for the detail, particularly for things like how causal mechanisms operate. Now, of course, if the tribunal doesn't understand a particular aspect of the pleading or finds them to be so vague and unparticularized that they are not clear or coherent, then that's a matter of concern. But it's always a matter of fact and degree. Where a pleading is complete in its basic averments, but the relevant averment is high level and not particularized in sufficient detail for the tribunal, then it's usually not appropriate to respond to that by an immediate application for strikeout. What you do is ask for further information or for further and better particulars. And if no such particulars are provided, then it might be appropriate to apply to strikeout. So I make all of those comments by way of preamble because I think they are important when it then comes to assessing these particular claims. Now, the judgment has got a long section on pleading the causal link between an infringement and the loss to the claimant. You'll see that at paragraphs 215 to 260. And it starts with direct competition law claims, and then it moves on to indirect competition law claims. And in that regard, it quotes very long passages from both Sainsbury's and MasterCard, both at first instance and in the Supreme Court, and then it goes into Merrick's. And one point that is emphasized by the tribunal on several occasions is that Merrick's, they say, is a relatively straightforward case because the initial overcharge is one that is itself reasonably easy to identify and compute. Now that may be so, but it doesn't mean that claims that don't have a readily identifiable overcharge at the outset can't or shouldn't be brought. And there are indeed many examples of cases and claims where one can't point to an identifiable clear amount of an initial overcharge. So for example, one example of an indirect purchaser claim that came before this court is that of McLaren, where the infringement was by sea carriers who provided services to car manufacturers, and the car manufacturers sold on to the consumers who made up the class. Now, the class consumers claim against the sea carriers alleged that the prices that they were charged for cars was inflated by reason of the fact that the car manufacturers passed on an overcharge that they were charged initially and they passed that on to the buyers of the car. Now, at the stage of pleading that type of indirect purchaser claim, one typically, the end customers, they don't know what the level of the initial overcharge was, nor do they know the extent of the passing on. And it's always possible that there was no initial overcharge, or that there was no passing on. And indeed, defendants frequently aver as much. But such indirect claims can nevertheless entirely properly be brought. And the claimants can assert, if properly advised, based upon the nature of the infringement, that such an infringement is liable to have led to initial overcharge. And they can assert, again, if properly advised, based upon the nature of the market and economic theory, that the overcharge was passed on. They don't know either of those things. They can't particularize either of those things, save by reference to what is in the public domain about the nature of the cartel and the nature of the markets involved. But provided that they are properly advised in the circumstances of the case, that such matters are plausible or likely, then they are entitled to assert those allegations and they're entitled to bring the claim. Now, whether there was an overcharge, whether it was passed on, that will be a matter for trial. And it may be that at trial there will be tremendous challenges forensically. But as Lord Briggs and the Supreme Court said, and as this court has emphasized, the cat must seek to rise to that challenge and not duck it. Now, in Merrick's, Lord Briggs referred to various methods of approximation and estimation. And one of the documents that he referred to in that regard was the Commission's guidance on quantifying damages claims. And that's quoted in paragraph 52 of Lord Briggs's judgment in Merrick's. And what that document shows is there are various different methods by which these indirect purchaser claims can be proved. And if I could just show you a brief passage from that document. It's in the Sixth Authorities bundle at tab 62. And if I could invite you to go to page 1995. And perhaps if I could just invite you to read paragraphs 164 to 167. So what we take from that is that indirect claimant claims don't always have to be proved by establishing the precise effect at each level of the causal chain, if you like, at each level of production and distribution. It's not always necessary to establish what's the initial overcharge at the direct purchaser level and then track that amount of overcharge through the various layers of the production chain down through to the end claimant. It is acceptable, according to the Commission, to seek to bypass those intermediate stages and instead establish the loss on the basis of a comparison of prices of the end product typically comparing the price of the product during the cartel with the price of the product before and or after the cartel, adjusted for other factors using regression analysis. And that's really quite an important observation in the context of our claim and the criticisms that are made of it by the tribunal. Because it seems to be that one of the main criticisms made by the tribunal is that we have not alleged the precise amount of the cost imposed by the cartelists on the non-respondent dealers, so on the competing non-infringing dealers. And the answer to that is actually simply, we don't have to quantify that cost separately. You can look at the spreads paid by the end customers, just as the customers of the baker can look to the prices of the bread charged by the baker to see the effect on their prices of the cartel that is further up the chain. You don't have to separately quantify the initial overcharge by the miller that is charged to the baker.
I think isn't the problem that that the CAT was identifying is that in your example you talk about a chain and a pass on down the chain.
Yes.
I think their concern was that there's a part of your claim which doesn't involve a chain.
Well, that's just not correct, I'm afraid, and I'll have to show
I mean,
you.
there are two parts of
Yes.
your claim. One is obviously people trading with the cartelists,
Yes.
and then there's the effect on the remainder of the market.
Yeah. Well, I have to talk you through it in due course,
Yeah.
but I think it may be more convenient just to talk you through when I come to it.
But I mean,
Yeah.
the type of situation that is identified here, amongst other things, and in, say, McLaren, was where there's a chain.
Yes, and there is a chain. There is a chain, and a
That's-
clearly alleged chain, as I'll show you in our case. It's slightly different because it's using this mechanism of adverse selection, informational asymmetry, but it's actually a very similar type of analysis and a very similar type of chain. I mean, if I could, maybe I'll summarize it now very briefly. So, the most basic level, you've got two different categories of dealers. You've got cartelist dealers, and you've got the non-cartelist dealers, effectively. And customers trade with the dealers, and then the dealers, both types of dealers, trade in the inter-dealer segment of the market. And effectively, the customer, in the most simple way, the customer comes along and says, I want a certain amount of currency, and the dealer provides it, and then they go into the inter-dealer market to lay off the inventory. And effectively, the adverse selection, at its most basic, is the notion that when the non-cartelist dealers go into the inter-dealer market, they are on occasion stung, basically, because in the meantime, after they've done the trade with the customer, they go to recoup their inventory or lay off their inventory in the inter-dealer market. And because of the cheating, effectively, by the cartelist dealers, the exchange rates have moved adversely. So they impose a cost, losses, in concrete terms, on the non-cartelist dealers. And so the non-cartelist dealers have an increased cost of doing business. And they seek to recoup that cost, that increased cost, by widening their prices, the spreads that they charge to their customers. And the cartelist dealers then, in the third stage of the analysis, then widen their own spreads in order to profit from it. And that is, it's essentially essentially a form of passing on, and it is
So
a form
so your case vis-a-vis the non-cartelist dealers,
yeah,
is founded on their having to go into the inter-dealer market
correct,
and trade with cartelist dealers
Correct.
who effectively overcharge them.
correct, exactly.
So there isn't a freestanding effect on the non-cartelist dealers, so by some sort of magical
No, there's no.
magic dust
No, there's no
syndrome,
magic
which
dust.
seems to
No.
be what the
It's very hard to.
CAT actually thought. That
Yes, I don't know. Very hard to tell what they thought. I think, but yes.
I mean, speaking for myself, I'd be very keen to be taken through that in a little detail to understand
Yes.
how that causal link is established.
Likewise.
Because going forward, if you go forward,
Yes.
that's on any view going to be a key question for whichever cat is seized of this case, because that is plainly going to be, as I would understand it,
Yes.
a principal battleground in these proceedings.
Well, yes. I mean, it's
And it does seem to be the area, putting it generically,
yes,
that plainly concerned this cat.
yes. Well, let me show you in more concrete terms.
Don't let me take you out of your
No,
point,
I think
don't think
well,
that would be wasted time to go
no,
through
I
it.
certainly plan to take you
detail.
through. Let me take you though to show you a little bit more about those the losses, the costs that are imposed on the non-cartelists, and let me show you that by the Sterling Lads decision that His Lord Justice Green referred to, because I think that shows it in quite concrete terms. Now, as you know, this is the third in a series of decisions. It's basically almost identical. The settlement decision is almost identical to the two decisions that we have in our case, but one has the advantage here of having a non-settlement version of the decision, so you can see it fleshed out. And if I could take you to that, it's in tab 60 of the authorities manual. And I would just, we refer to a number of different passages from the decision in our skeleton argument, but let me just, if I may, just take you to some of them. If you go to page 1752, you see at paragraph 170, the exchange of information on outstanding customers' orders concerned 1, customer conditional orders, 2, orders for the fix, and 3, immediate orders. Exactly the same 3 categories of trades that are at issue in the infringements with which we are concerned. The disclosure of information related to customers' orders removed some of the inherent uncertainties that are inherent to forex trading activities. These exchanges increased the level of transparency for the chat room's members about their trading activities and about the potential direction of the involved exchange rates. These information exchanges were taken into account by the participating traders to devise their future trading strategy and resulted in an asymmetry of information between the SDG Lads chat room participating traders and the non-participating traders, providing the former with a competitive advantage and increasing the likelihood that they would make a profit from it. And we infer they did make a profit from it. And the counterparty are part of the profit from it, since they engaged in this conduct for several years and on an almost daily basis. And we say that the counterpart of the participating traders profiting from it is that the non-participating traders made losses from it.
I more or less say that in the decision. I think it's 385 onwards, particularly round 394.
Yes.
But of course, given it's an object case, it seems to us that they're either saying systemically there must have been a loss, or because of the system and the intrinsic anti-competitive nature of what's happening, as a matter of likelihood, I think they use the word likelihood once, there was a loss. But they then don't go on and actually track it through dollar by dollar.
No.
It's, if you like, an aggregated damages type analysis of causation.
Yes. Yes. Indeed. And I concur entirely, my lord. And if one goes forward to page 1776, one sees again in relation now to the exchange of information on open risk positions by the participating traders, they again say that gives them an insight, and you see in the last sentence, reducing uncertainty and giving them a competitive advantage over the non-participating traders. And if one goes forward to page 1780, one sees the exchanges on bid ask spreads, had a similar effect, and then in the passages that my Lord Justice Green referred to, starting on page 1842 and through to 1844, they conclude on 1844 that the extensive exchanges of current or forward-looking commercially sensitive information reduced uncertainty between the participating undertakings on their respective trading strategies and of the direction in which the market might move. And that gave the participating undertakings an advantage, a competitive advantage. And you see over the page, paragraph 401 and paragraph 404. That's the conclusion. So clearly, information exchanges of this type are at least potentially capable of affecting transparency and asymmetry of information in the market, leading to effects on prices, leading to competitive advantages over non-participating traders, and making them suffer losses at the expense of the participating traders. Now, the judgment, coming back to the judgment, it notes on a number of occasions that it is very wary of pleading loss by reference to economic theory. You see that in paragraph 232, where it says economic theory does not in and of itself constitute an arguable legal claim, and paragraph 234, subparagraph 2, where it says it doesn't consider that market-wide harm cases can be pleaded at the level of economic theory only. Now, of course, the tribunal did not have the benefit of this court's judgment in Gutmann, and Gutmann recognizes, in particular at paragraph 54, that the methodology in most of these cases is based upon a counterfactual model, which is quintessentially hypothetical, and I quote, "and for this reason will use assumption and models and frequently use regression analysis. It is therefore not a fair criticism to make of a methodology that is hypothetical." Or that goes on to say there will need to be some factual basis for the assumptions and models deployed, hence the reference in Microsoft to the methodology not being purely theoretical or hypothetical. But it is certainly not a fair characterization of our claim to say that it is pleaded at the level of theory only. The expert report of Professor Breeden, which I'll show you in a moment, is by a professional steeped in the study of this market, of this particular market. It's very much based on the facts of the infringement as they are currently known and understood. And it's based on expert advice about the nature of the market and the importance of informational asymmetries in that market. And as I'll show you, the experts conclude that the acts of the defendants would have been likely to have caused harm to the claimants for the reasons and the mechanisms they explain. And they also explain how they intend to measure that potential price impact and the data and the documents that will be available to do so. So it is not pleading in any sense by reference to theory alone. And of course, the concerns that the tribunal also expresses about the trial process is not, they say it's in paragraph 233, that is not a case as capable of being tried by a court. That is, I'm afraid, runs straight into what Lord Briggs says in Merrick's about the duty of the court, if necessary, to use estimation to overcome forensic difficulties. And one of the points that the tribunal entirely leaves out of account, for reasons that are inexplicable, is that there is, in relation to these claims, a profound asymmetry of information between the claimants and the defendants. Because the claimants, we don't have the details of the chats, thousands and thousands of pages of the underlying documentary evidence, and we don't have any of the data in relation to these trades.
Can you help us with this? what would disclosure provide to you? And of course, in the Credit Suisse, the non-settlement case, you could get all those documents. So you know those documents exist, both as individual documents and by category.
Yes.
And that's going to be the chat room type of data.
Yes.
What other
Well,
documents might there be?
the documents will be the details of all the underlying infringement. So you'll be able to see all of the instances of collusion in the chat. So you'll be able to work out what was the nature of the collusion, how was it intended to affect the market, how frequent it was.
Does that necessarily tell you the latter? Because I can understand it tells you the nature of the cartel, its frequency, its recurrency,
yes.
the type of data that is being used, what it's being used for, its systemic effect.
Yes.
Is it going to tell you how much gain each of the cartelists made, or might it give you an indication? And if that, might it then give you an indication of how much loss was transferred to the claimants?
It's going to be possible, but it's going to be really difficult, I think, to try to quantify that first stage of the precise amount of because it is the effect of hundreds and hundreds of individual trades, and it's also the effect. The way that it works is effectively there is an increased the non-participating dealers are suffering a loss occasionally when they are struck by by the trades in which they are trading against a colluder, and so that affects their average cost of doing business. And the way that it is hypothesized that impacts them is that they need to recoup that cost, otherwise they are either going to go out of business or certainly make a lot less money than they were before, by increasing their own prices. And they increase their own prices by widening their spreads. And what we will have, and the colluding dealers will do the same, because they can effectively widen their spreads under the umbrella of the non-colluding dealers. And Professor Bernheim describes this as a classic cartel mechanism of you raise your rivals' costs, so they push up their prices, so you can too, basically.
But that's the theory.
That's
the mechanism. I'm still.
That's the mechanism.
holding my- Yeah, I'm still.
So the proposal to test it is to see were the dealers charging wider spreads during the cartel as compared to before and after the cartel, and regression analysis will be used to control for all the other factors that are capable of affecting the cartel, affecting the spreads.
So this is whether the non-participating dealers
Both
increase their prices as a consequence of their dealings with the cartelists.
both the non-participating dealers and the participating dealers will both, we hypothesize, increase their spreads to customers, effectively their prices to customers, because of this conduct. The non-participating half of the market, because they faced an increased cost, and the participating because they can just make more money that way.
Goes back to the question I asked you a moment ago, because it may be my simply not following the point.
Yeah.
But I thought that what the CAT was saying was that somehow your case was that the non-participating dealers somehow put their prices up because they saw that the participating dealers were putting their prices up, so they all went up together. And the CAT says somewhere that this is all completely illogical, because why would non-participating dealers increase their prices as opposed to continuing to be more competitive? Your point is that the reason why they're increasing their prices is because they have to go into the inter-dealer market and trade with the cartelists.
Funnily enough,
everybody's price goes up.
Everybody's price goes up.
And the cartelists then think, we can put our prices up a bit more.
Yes, indeed. And
I follow that point.
Now,
that's the theory, if you like.
That's the theory.
When it comes to putting flesh on those bones, that's all you say. That's all a matter for evidence and disclosure in due course.
That's correct. That's correct.
But can you add, Lord Justice Green's point? What documents will you get? I mean, I understand that as between you and the cartelists, you'll get the documents relating to the dealers who are cartelists. What about the other part of the market?
Well, it may be that it's necessary to make third-party disclosure applications against non-participating dealers to identify their spreads. Or it may be that one can use the cartelist's wider spreads and assume that they would be a proxy for the whole market.
So where, is this explained somewhere in the document?
Yes, it's in. There's a whole debate about the extent of, or not debate, explanation of the precise extent of disclosure that may or may not be required.
Because that, unless I've missed it, I might well have
Yeah.
done.
But it's quite
It doesn't feature in the
no.
CAT's judgment.
No, it doesn't, because they're not concerned with this. This is not in their eyes. There's not a problem with disclosure. They say for some reason for various reasons they seek to specify. They suggest that it's not properly, the causal mechanisms are not properly pleaded. So
one way of identifying the causal mechanisms and explaining, as it were, that they are, and when you say pleaded, I think you mean both pleaded in the narrow sense
Yes.
and by reference to other documents,
Yes.
is actually tested by saying, well, to which pleaded issues will disclosure go? So in other words, where, as my lord said, what documents are you looking to get and from where?
well, the documents are the documents. The fundamental documents are twofold. One are the chats showing the underlying infringement, and the other are the data, because the defendant. I should show you from the expert report. The defendant cartelists will all have their own trading data about what spreads they charge.
Yes.
So we will be able to see. We will get, and it's clear from the US proceedings that it was provided. It exists. You will get all of the trading data to be able to see.
But your claim is not limited to.
No, it's not. And there's
it's the second bit, which is where there's
Yes.
the biggest potential disconnect.
well, there's the possibility. There's always the possibility of seeking if it's necessary, to seek third-party disclosure from the non-participating.
Anyway, you're going to show us where this is.
Yes.
set
The,
up.
the trading data will include the inter-dealer market data.
It may. It to some degree it may, but it's not clear to the extent to which it's going to be possible to interrogate that data. I think it's right to say.
To what extent?
How do you make good a case that they were, as it were, overcharging in the inter-dealer market?
Well, they were effectively you do it by reference to the documentary record and then the effect on the output in terms of spreads.
Before and after analysis.
The before and after analysis. And that's why the example with the bread is rather.
Yeah,
And I saw a reference in one of the decisions to the dealers' brokers' profitability of their revenues being, or their bonuses being reflected. I mean, there may be all sorts
There
of.
may be profitability. Yes, profitability may be it's certainly something that we
That
propose.
horizontal exchange may be one category.
Yes.
There may though be internal emails, notes, analysis, communications, which are basically saying, we've made more than we would otherwise.
Yes, no, indeed, and
those sorts of assessments.
indeed, and profitability analysis is one of the things that we propose to
That's
do.
all in the cartelists
Yes,
bubble.
yes, it is.
I'm really interested in the other,
In the non-cartellist.
in the other area.
It
which is-
may be. Well, I have to show you. I have to show you. But
But just coming back to that,
Hmm.
the question is what would be a proxy for the gain they've obtained from the non-cartelist? It might be the profitability analysis,
absolutely,
even though you wouldn't have any communication with the non-cartelist.
no, indeed. So
Yeah.
now, could I know that you're itching to see the pleadings in the widest sense of the word, and I want to take you to them. Before I do, I just want to show what the tribunal did appreciate about the case of the applicant. If we go to paragraph 136, and perhaps, actually, forgive me, if we go to page 325, it's paragraph 186.
186, paragraph 186.
Paragraph 186. You see, I think it's the fourth sentence down. You say, let me read you the whole paragraph. Although the applications differ in a number of respects, they have a number of important aspects in common. While the class definitions differ, they're both brought on behalf of the generality of customers using the FX markets. including not only those who traded with respondents, but also those who traded with other dealers. The proposed claims embrace trades in all G10 currency pairs. Both applications assert that the respondents, through the unlawful actions found in the decisions, caused customers loss through the widening of spreads. That's to say, customers in general bought currency at a higher price and sold it at a lower price than they would in the absence of the anti-competitive behavior found. So that they recognize that causation is alleged in the form of higher spreads. So it's just not right to say that, for the tribunal to say causality wasn't alleged. Well, it's recognizing there at a high level, at least, that it was alleged. Secondly, it's important to note that the tribunal recognized the plausibility of the basic theory of adverse selection or informational asymmetry on which the causal mechanisms were based. Again, I'll just give you the references, if I may, paragraph 141 and paragraph 231. So they don't deny the plausibility of asymmetric information. You would have seen that in the passages that have already been read to you. And they also recognize that, generally speaking, a cost consisting of an overcharge will be passed on by a recipient to its own customers. And again, I'll give you the reference. That's paragraph 226, subparagraph 4. But then the tribunal makes a number of assertions about our case, which I'm afraid are just demonstrably wrong. And what I'd like, the way I'd like to deal with this, if I may, is to show you, if you like, the four key incorrect assertions about the case. And then I'm going to take you, if I may, through the, I'll later take you through the document that I've handed up for the other criticisms. Now, if I could just identify the assertions. The first is that there's no pleaded allegation of causation at all. I think you've already seen that. It's in the last paragraph of 240 and subparagraph 241.1. They suggest there's in reality no pleaded causation at all. The second allegation we say is incorrect is that we don't make it clear whether or how we would prove causation. And you see that if you go to page 332. I could invite you to turn that up. Page 332, paragraph 196, subparagraph 1. And you see that...
Right, can I just...
yes.
Paragraph 241.1.
Yes.
They don't say you don't plead causation. It's not said you don't make an allegation of causation. Which I think is what you put it.
Well, they say in reality, they say there. I think there's no...
Yeah, but I mean, it's their complaint is not that you haven't said you haven't made a bare allegation of causation. I think their concern is that in reality there's no facts.
It's just a bare assertion.
Well, I'll tell you that's not correct.
I mean, I don't think they were saying that you hadn't technically said that this conduct caused you loss. I think they're looking for...
I think that must be what they mean. They do on certain occasions say there is in reality no pleaded case of causation.
But they say no. They say although the nature of the claims are understood at the theoretical level,
yes,
there is no reality, no pleaded case. So I think they're distinguishing between theory and particularisation.
Yes. Well, if one looks at 196.1 on page 332, they make another distinct allegation, which is they say, you see in the third, I think it's the fourth sentence, they say, in neither application, they say, is it made clear whether the applicants are intending to rely solely on the plausibility of their economic theories to make good their claims, or whether they intend to prove that what their experts regarded as plausible actually occurred. In both applications, the quantification of loss is to be based on a regression analysis of trading records. In neither case is it stated whether this statistical analysis is also to be used to demonstrate that the damage actually occurred. And that is, as I show you, incorrect. We make it very clear that the statistical analysis is also to be used to assist in showing whether there was causation. Now, the third allegation, main allegation is wrong, is it said that the O'Higgins applicant never initially alleged reliance on collusion in the setting of spreads. I'll just give you the reference to that. That's page 367. It's paragraph 238, subparagraph 3, Roman 1. That's in the first. That's set out in the table that's in the document that I've handed up. And the fourth, a key incorrect allegation, is that we never identified the nature of the increased cost that we said was imposed upon the non-respondent dealers, and that's in paragraph 238, subparagraph 3, Roman 4, which is also in the paper in front of you. Now, to show you that all of those points are wrong, I'm going to take you, if I may, on a whistle-stop tour through our claim. And let me start just with the claim form. And of course, bearing in mind this didn't come in splendid isolation. You'll see that if you could take that up in the supplemental bundle, please, at tab 20. If you go to page 1476, we say, in paragraph 27, first we say, as to quantum, the breaches of competition law were committed in order to manipulate and obtain profit in the FX market. They are expected to have caused loss, not only to the proposed defendant's customers, but also to other persons who engaged in FX trading during the relevant period. And over the page 29, you'll see that we then say that the proposed representatives notes the following features of the FX market, and which are discussed by Professor Breeden in his report, and which in his view make it likely that the collusive arrangements in which the proposed defendants participated will have led members of the proposed class to suffer substantial losses. So we clearly make a bare allegation of causation, and then in paragraph 43, which you'll find on page 1494, we identify the common issues, and you will see that.
Sorry, I'm
yes.
struggling to see what at the moment you're doing. I mean, paragraph 29
Yes.
sets out a theory. That's the theory of harm.
Yes. Well, it's a theory of harm. That's absolutely right. It sets out a theory of harm and explains in it, and it alleges causation. I'm simply showing at this point that we allege causation, and I want to show you, if I may, the issue that we identify, which is on page 1494 at paragraph 43, subparagraph 4. And the issue we identify is whether and to what extent the infringements had an impact on the price at which relevant foreign exchange transactions were concluded in the relevant period, the price impact. And so it is clear, even from the issue, that we are identifying causation, whether the infringements had a loss, as well as quantum, what extent. And if one goes on to 45.2, so over the page at 1495, it then briefly summarizes and cross-refers to the expert evidence for the details of causation and damage. And note, if you note in particular, subparagraph 2b there on 1495, we note that Professor Breeden will estimate the impact of the cartels on the spread. Different spreads will be calculated for different mid prices, and Professor Breeden will then undertake a series of regression analyses with the various spread metrics as dependent variables and with appropriate controls. This will enable him to measure the difference between the spreads during and after the relevant period. Ultimately, they will generate a figure representing the average size of the manipulation across the relevant period. And you see in subparagraph A above that, we also, as Lord Justice Green anticipated, anticipate also to look at profitability, the per trade revenue achieved by dealers during the relevant period, with the per trade revenue achieved by them after the period. Now, it is fair to say that the detail of the causal mechanism is set out in Professor Breeden's report.
And that, when you say estimate the spread and
Yes.
the like, and take a regression analysis, that's with both cartellist dealers and non-cartellist dealers.
Yes.
So in sub 3, you talk about the information that will support that, and it says the proposed representative believes that this is information that will be in the possession of the proposed defendants and can be provided by way of disclosure. Well, why would that be for the non-cartellists?
Well, I'll show you if I may. The non-cartellist information won't be, but what Professor Breeden suggests is that it may be possible to extrapolate based upon the effect on the cartellist spreads, what will happen for the non-respondent. And I'll show you that.
But at the moment, I mean, we haven't taken us the Breeden report, and you may well be planning to.
I am.
Yes, I'll hold
Yes,
I'll
yes.
hold
That's in
my
the next
question.
tab, at tab 22.
Okay.
You'll see, this is Professor Breeden's first report. If you go to page 1602, you will see that at 1.1 and 1.3 that he's Professor of Economics and Finance at Queen Mary University. He specialises in the study of FX market microstructure, that's the FX market. He's written books and articles on the topic. He was a trader who worked at the Bank of England, and he notes, if you go over the page, 1.6, he acknowledges that he's been assisted by the industry expertise of a recently former FX trader, Mr. Reto Feller of Velador. So this is not just a theoretical economist, he is an expert in this particular industry, assisted by a trader who is working in the industry now. And if one goes to 1609, we see he describes the FX market. He explains how FX dealers or market makers operate by setting prices in the form of bid-ask spreads. If you go to page 1611, you will see that he explains how, in paragraph 2.9, how dealers or market makers seek to maintain a neutral inventory position. At paragraph 2.15, you see he explains how when a customer trades with the dealer then turns to trade to lay off trades on what is called the interdealer market. On page 1613, you see at paragraph 2.19, he notes that market making activity across the FX market was dominated by a relatively small group of dealer banks. And this is not a perfectly competitive market, as the tribunal seemed to think. And he explained that in his first report. He explains that the market share of the colluding dealers was about 45%.
Of which market?
Of the FX FX worldwide market. The 2.21, you can see from the table above, it can see that the total average worldwide market share of the addressee banks was in excess of 45%. And he then turns to describe the infringing conduct that those banks have engaged in. You see that from page 1621 onwards. And you see, just en passant, 1624, at the bottom of the page, you see a reference there to one of the infringing conduct being exchange of information on bid-ask spreads. So he identifies that as part of the infringing conduct. And then on page 1626, you will see a heading the FX cartels and causation of loss. And he says, in the previous section, I set out the anti-competitive conduct arising from the FX cartels. As a result of this anti-competitive conduct, I consider that the FX cartels are highly likely to have caused loss to the class. In this section, I set out my reasons as to why such loss is likely to have resulted. Namely, 1, academic literature supports the view that the type of conduct set out in the EC decisions would have affected FX pricing and caused loss. B, proceedings in the United States provide information regarding the loss caused as a result of the FX cartels and illustrates how exchange of order flow information can provide a competitive advantage. The conduct would have, these notes would affect pricing beyond G10 currencies. And he then sets out his reasons and his explanation. And one sees 4.3, he explains the notion of the importance of asymmetric information in these markets, and he does so by reference to a number of academic papers. He notes in 4.4 that as the colluding group have an informational advantage, non-colluding dealers on all trading venues will have to quote wider spreads, since to make a normal profit, they must make a larger profit from the rest of their trades in order to offset the losses that they make to more informed traders. Even dealers that don't trade directly with the colluding group will be affected. And he notes, moreover, then he notes this, the last sentence, moreover, whilst colluding market makers in principle could charge narrower spreads as a result of this informational advantage, there is implicit agreement within the FX cartels to keep spreads wide, at or close to those of the non-colluding group, and so earn abnormal profits. So
what's meant by implicit agreement?
this is that he explains in subsequent reports, he means the collusion on spreads, is what he's referring to.
That, in other words,
the exchanges of information.
But it's implicit they don't undercut each other.
Yes.
I mean, that's
Exactly,
what he's really
exactly.
talking about there. They have a choice.
Yeah, that's
They
right.
can either undercut everybody else or
Yes.
just make more profit.
Yes,
and
exactly.
he says it's
And they
much more
choose-
likely
They make more profit, and the reason one of the reasons he says is because of their, he says there is because of the implicit, because of an implicit agreement. In fact, not quite, because of their collusion on spreads. That adds to the.
So is he referring effectively to the collusion found by the Commission to be
Correct.
It's sort of sort of saying it's sort of counterintuitive. People who engage in this sort of conduct are going to then engage in competitive activity by undercutting each other.
Yes.
Broadly speaking.
Yes. Well, we'll come on to Professor Bernheim. He looks at it from an antitrust economist's perspective, which is, but yes, what he's saying here is that the colluding market makers would be likely to make their spreads wide, and he
Well,
referring
they're likely
there.
to be colluding with each other for very long if they're busy cutting each other's throats.
Well,
Isn't it? So what they do is they maximise their own profits and
yes,
everybody's happy.
and everybody's happy.
on a similar volume, but it's still going to be. I mean, the Commission says that a small increase in spread on a large volume leads to very large profits,
Yes.
very large gains. So you don't have to compete for volume if you're making extra margin on the same volume.
Correct. And you see in 4.5, he says, for the avoidance of doubt, when discussing the profits made by dealers in this section, I'm also referring to the increased cost and therefore loss to the class. When non-colluding dealers, for example, have to quote wider spreads in order to make a larger profit due to the activities of the colluding group, the impact of this is an increased cost to the class equal and inverse to the increased profit to the dealers. And you see at 4.9, he discusses more detail. He says it appears that they not only shared recent order flow information, which gave them a competitive advantage over other dealers and customers, but they also shared information on ongoing planned trading activities and therefore prospective order flow. And this allowed them to, he puts it, collusively front-run customer orders. So trade before the order arrives, so the market is temporarily moved in a way that is disadvantageous to the customer, and made excess dealer revenue on trades by widening their bizarre spreads. Again, referred to for convenience as spread manipulation. So how can it be said that this was sort of something that we borrowed from the Evans camp? It's just not correct, I'm afraid. You see collusion on spreads featuring quite heavily in Professor Breeden's initial report, which appeared 4.5 months before the Evans claim
That's a date
surfaced.
ready for Wednesday.
Yes, I'm afraid it is. and that's the only point I'm going to make. That's a dig for Wednesday, but I do. Now, if one goes on in this, you see that he then, if you go to, in particular, to paragraph 4.35, he identifies. Having identified the various reporting dealers, both the cartelists and the non-cartelists, he then states his conclusion. The FX cartels involve conduct such as the exchange of commercially sensitive information and trading plans. Academic theory suggests that the FX cartels will have caused loss, since such informational advantage could allow traders to make excess revenue, largely at the expense of other less informed traders, that is, members of the class.
And just standing back, that's a sort of legal theory.
Yes.
An aggregate damages case, how does that impact on the nature of causation that has to be established?
Well, in an aggregate damages case, as you held in Gutman, one's concerned only with aggregate damages and not with damages to individual members of the class. So if a particular member of the class didn't have their spread widened, it doesn't matter. So what one is looking at is averages. Did this conduct, on average, lead ultimately to wider spreads to the class as a whole? And that's precisely what he then comes on to on page 1639.
I suppose I'm asking perhaps the Ashton proceedings are the proceedings in the United States.
Yes, but involving the same cartel.
But it's the same cartel, isn't it? It's the Essex,
Yes.
Essex Express, or
Yes.
I get confused as to whether it's Essex Lads or Sterling
Yes, well.
Express or
Yes.
it's the Essex
Yes.
Express.
It's all the same. And in any event, even if it's not the same, it's the same type of conduct.
Yeah. Well, I follow that point.
Yes.
I just it is actually.
Yes, no, it's the very
I haven't read
same.
the detail of
Yes.
411 and following, but what
Yes.
he says in his conclusion is such loss was evidenced in the Ashton proceedings relating to the Essex.
Yes, that's right. So he's referring, so all of this about it being entirely theoretical, he's not quite
So it's
sure
an
what.
example
it's
of
an
an actual
example.
loss that's been
Yes.
suffered.
Yes, yes.
Can I just come back to the question? I'm tracking my own mind with what's meant.
Sorry. Yes, okay, I don't. Yes, forgive me.
Just in terms of what has to be pleaded / established for certification in an aggregate damages case, where we're trying to establish from a global perspective that there was loss. So you've got the Commission saying there in a likelihood or a systemically likely to be
Yes.
harm.
Yeah.
You've got here in this report saying the FX cartel will have caused loss. How much further does one have to go in an aggregate damages case? Assuming one can establish that.
Yeah.
No,
No,
because you don't have to go down to the individual.
no,
The burden on causation is different. It's obviously still a burden.
yes.
We're just trying to understand what that means in practical terms.
I have to show a plausible case and a way of testing
He
it.
says academic theory suggests that the cartels will have caused loss.
Well-
I mean, the challenge is for you to, as the tribunal put it, to make good that what academic theory suggests will have happened did happen.
Yes, but how does one do that unless, other than you first of all you go to one of the leading experts on this market in the country, and you ask him on the basis of the
Well, at the
academic.
initial stage,
Yes, well you don't know for sure, but if one goes to page 1639, at the top of the page he says, in the previous section, I set out a brief overview of the FX cartels and the reasons why I consider the FX cartels are highly likely to have caused loss. So it's not just that he's saying academic theory suggests this. He's saying, I know these markets, I know the academic articles say this, and I consider on the basis of those academic theory, looked at in light of what we know about how these cartels operated, and you see that he goes through not just the Commission's description of the cartels, but a particular example, as my lord says, of a particular trade and how that's likely to have caused loss. So what more could one possibly ask for at this stage? And then he then goes on at 5.1 to say, in this section, I explain why this loss is likely to have extended to the class as a whole, and in particular individual customers who traded with dealers, market makers who are not addressees of the EC decisions. And then he goes again to set out much more elegantly than I have done to you the theory of how the impact of this adverse selection risk will redound market-wide. And he sets out...
What weight we attach to the Commission decision? The Commission can't impose fines unless it meets relatively high standard of proof.
Well, the Commission decisions here are settlement decisions, so they're entirely...
I mean the Essex lads, which is not a settlement decision, where you have a more detailed analysis.
The Sterling lads, yes.
Sterling lads, yes. Where you have a more detailed analysis of effects.
Well, I think one can, in effect, one can just simply take comfort from the fact that Professor Breeden has correctly predicted the effects that these infringements would be likely to have, as subsequently found by the Commission.
They've made findings.
I mean, yes.
The findings. I mean, how do you encapsulate what the findings were? Are they findings of systemic effect, or probability, or likelihood, or more than likelihood, or bearing in mind what they have to establish to justify the imposition of a fine? What is the probative value of those observations around paragraphs 385 to 400?
Yes. Well, I think you're entitled to say that Professor Breeden's analysis, based on his knowledge of the market, is corroborated by the findings in the European Commission decision.
Let's assume you just cited to us the decision and not Professor Breeden.
Yes.
What would we take from the decision?
Well, it would have some probative value, as the Commission decisions have.
It wouldn't be binding.
It would not be binding, but it would be admissible.
It's not binding because it's binding on the addressee.
Yes.
No.
But it's admissible. It's admissible. It's admissible. It's an exception to the rule in Hollington and Hewthorne. There's House of Lords authority.
Some authority on this.
Yes, there is. There's House of Lords authority. It's Lord Hoffman in Courage and Crean. Yes, I think it's Lord Hoffman in Courage and Crean.
I argued it on memory.
That's why you remember.
Well, there we are.
Right.
I passed the exam. So it would be itself admissible. One has the explanation across these paragraphs from 5.9 and following as to how it would be likely to affect the entire class. And in fact, and you see 5.10 on page 1642, the wider bid-ask spreads would have injured class members on all trading venues in the following ways. Class members would have traded on these wider bid-ask spreads and thus would have paid higher transaction costs, and bid-ask spreads in the inter-dealer market would set reference prices for the market as a whole. In short, even if class members didn't trade directly with the proposed defendants, wider bid-ask spreads resulting from the increased adverse selection risk driven by the proposed defendants' agreements and conduct would necessarily have affected bid-ask spreads on all venues, causing injury to all class members trading during the cartel period. Given their extensive and ongoing trading activities, in addition to their large joint market share, the proposed defendants' collusive conduct would affect the entire market. So those are then his conclusions on causation of loss and how loss would be caused to the class. And then in section 6, which you see starting at 1644, he sets out a proposed methodology of how he will measure the extent of loss suffered by the class as a result of the FX cartels. And you see 6.4, in order to calculate the loss suffered by the class, I propose to first assess the impact that the FX cartels had on pricing to class members. I propose to compare the prices the class actually paid for spot and outward forwards during the cartel periods with those prevailing after the cartel period, the clean period, which will be used as a proxy. And he explains why a clean period is useful. And then he goes into some depth into the various ways that bid-ask spreads can be measured. He proposes in particular to use not just what he calls the effective spread, which is the spread at a single point in time, but also the realized spread, which is the spread at a slightly different points in time. And he explains that the reason for doing that is to be able to measure the harmful effect of more of the collusive conduct, in particular the effect on benchmark trades and resting orders. And if you then go to 6.20, he concludes on that how the effective and realized spreads will be useful for measuring the impact of different types of wrongdoing. And from 6.22 onwards, he explains how the realized spread will usefully be able to capture the effect of these other forms of collusive front running and other forms of collusion. We say that if you go on, he then 6.36, you see the data required. Page 1655, the data required to calculate the pricing impact of the cartels. He explains the different, he says, to calculate the pricing impact of the cartels, I require information from the proposed defendants, or possibly even third parties, including but not limited to, and then he sets out the data he needs, how he's going to estimate it, the apportionment of loss, and then he goes on to a preliminary assessment of loss, and he provides a detailed assessment of loss, and then he summarizes conclusions. Now, this was then supplemented, this report, by a further expert report, that of Professor Bernheim. And if we could go to that, please. This is in the next volume, this is volume 2, page 1758, tab 23. Now, Professor Bernheim is probably one of the most distinguished expert economists ever to grace an English courtroom. He is the chair of the Department of Economics at Stanford University, and he is by any measure a world expert on the economics of cartels and competition law infringements, and indeed econometric techniques. And if one goes to page 1767, one sees that he identifies, like Professor Breeden, the spreads as the proxy of price in this market. And one goes forward, paragraph 31, he explains the two different measures of the spread, the effective spread and the realized spread. And he recognizes there that the realized spread captures the difference between the spreads at different points in time. And if one, I invite you in due course, I won't read it to you now, to read all of paragraph 36 to 43, where he explains himself, he explains in his own way the causal mechanisms. You see on the top of page 1771, overview of cartel mechanisms. And if I could just draw your attention to paragraph 43 on page 1773, he says, by inducing competing dealers to widen their spreads, the collusive exchange of information among cartel dealers would have relaxed the competitive constraints that discipline their own bid-ask spreads. They may be expected to have responded to this development by raising their own spreads, both individually and in some cases in concert. And that's, as a result, the cartels may be expected to have elevated bid-ask spreads market-wide relative to the spreads that would have prevailed without collusion. In consequence, customers would have suffered harm by virtue of paying a higher price for FX transaction services than they would have paid but for the cartels. So he too, there is identifying the collusion as the contributory mechanism at this stage where the cartel dealers effectively are raising their own spread prices in light of the rising prices of the non-respondent dealers. Now I could of course read Professor Bernheim's report to you, but you will see that on the subsequent pages he explains how cartels are liable to have had an impact on effective and realised spreads. He explains how he plans to collaborate with Professor Breeden to use regression analysis to measure the existence and extent of that impact, how he will use regression to isolate the cartel effect from other effects, how he will distinguish between different time periods and types of trades and currencies. And he goes into what data he anticipates will be available to him and how he will use that to calculate damages to the class. Now, it is an unfortunate but rather extraordinary feature of this entire very long judgment that there are only very limited extracts from Professor Breeden's report referred to, and no mention at all of the content of Professor Bernheim's reports, save for in the appendix where the evidence is listed. Now,
just to read on,
yes.
I mean, you've been trying to keep pace with it, but in Professor Breeden's report, which the paragraph that's referred to by Professor Bernheim, which is 659, which is this provisional plan to calculate the loss suffered.
Yes.
I understand the concept of regression analysis for the trading with the cartelists. I'm struggling to understand 659 sub C.
Forgive me,
659 sub C, subsection C.
659.
1660.
Oh, this is in Breeden, is it?
Yeah,
okay.
it's Professor Bernheim refers back to it.
Oh, right. Yes.
Just to the paragraph you just referred us to.
This is a page number 6.
Sorry.
I'm
let me try again. Page 1784.
Oh, yes.
You referred us to paragraph 74 of Professor Bernheim's report. And the first thing he says is to measure which you said,
yes.
to measure the overcharge resulting from the FX cartels, Professor Breeden proposes the use of regression analysis.
Yes.
The footnote is reference back to paragraph 659
No, yes.
of Breeden.
Yeah.
I was asking you about 659 sub C.
I'm so sorry.
Sorry, no,
I'm with you now.
So if you look at, I understand 659A and B.
Yes.
I haven't yet seen some sort of explanation about how you get from B to C.
But what he intends to do, you see it in 654, is he proposes at this stage to extrapolate the amount to take account of the proportion of the market. He's assuming effectively. He proposes to assume that the effect on the spreads of the non-respondent dealers will be the same as the respondent dealers. But he goes on in his later reports. Actually, it might be 16. Yes.
I mean, in very broad terms, if the economic theory is the one you've identified, which is that the prices charged by the non-cartelists will have gone up to the same extent as the prices charged by the cartelists.
Yes.
So he will have information about the trades between the class and the cartelists, which on the basis that the cartelists comprise 45% of the market, let's say, you then extrapolate that and you
That's exactly right.
double it, as it
But
were.
to
And then, no, you probably don't double it because you then have to engage in no doubt in
But
reductions for various reasons.
Yes.
But you get to a figure
yes, that
is a market-wide figure.
that's exactly right. But he also acknowledges if you go to the top of 1660, he says in the event that third-party disclosure is sought and obtained, a similar analysis could be undertaken for any third-party non-defendant banks to reduce the proportion of the aggregate damages which are calculated by way of extrapolation. So, and forgive me, I don't have the references at my fingertips. They may be in subsequent reports, which are not in the bundle, in fact, or parts of reports which are in the bundle. But effectively the approach taken is it may be necessary or it may not be necessary to obtain third-party disclosure from non-respondent banks. We'll wait and see that's for down the road. But it is recognised that may be the case.
Right, so
And he contemplates that
It
that's
may
a
be that,
possibility
yes, and he
when
said, and he
he
contemplates
lists the
that's
data in
possible.
636 because he says there,
And I think,
information from the proposed defence or possibly even third party.
indeed.
So,
And-
so the focus is on disclosure from the cartelist defendants. Do the exercise, the regression analysis, and
Yes.
spreads as he's indicated, clean period
Yes.
of the cartel.
Yes,
Reach conclusions as regards the effect that the cartelists had on
yes,
their market, either trades with
Correct.
them.
correct.
And then at the moment, it's extrapolate that just on essentially market share or the like
That
to the remainder of the market, because the claim covers
yes,
losses caused in dealings by the class members with non-cartelist banks.
that's
And the extrapolation is really nothing more than, or sorry, it may
Maybe,
be dressed up in a
yes,
different way,
yes,
but it's effectively
yes.
a market share.
Yes, exactly. But he also contemplates that it may be necessary to do something, and he expands on this, I think, in his subsequent reports on the nature of the. I do recall a section where he goes into a little more detail, I think in response to a criticism from Evans possibly about this or the respondents, and he makes quite clear that he's got an open mind about the need for further third-party disclosure.
Right, but on-
Which it may be, for example, it might be possible to say, well, the other biggest bank is Deutsche Bank, so one just needs there
But on the causation
test
question,
Yes,
when you're looking at the cartelists, you can say, is the academic theory borne out by the numbers, because you've got the numbers.
yes,
You can, in a sense,
Correct.
check
yes,
causation, you can prove causation.
yes,
The proof of causation as regards the non-cartelists is not possible in that way. You just simply say you just assume and extrapolate out,
yes.
unless you.
Yes, at this stage, it's a provisional methodology, and he acknowledges that it may be appropriate to obtain third-party data.
Which would allow you
Which would allow
perhaps to
you to do.
cross-check or the like.
Exactly. Now you may say, well, this is all very well, but it's all buried in the expert evidence. But actually, we pleaded all of this out in outline, not once, but twice. The first time was in a document which was a neutral statement that was served in advance of the hearing. And you see that in volume 3, at tab 60. Forgive me.
Sorry, can you give me that reference again?
It's volume 3 supplemental bundle, tab 60, page 3449. And we were asked at the pre-trial review, the pre-hearing review, to produce a neutral statement of the Higgins PCR on the merits, and Evans did the same. Again, this gets no reference in the judgment, I don't think. If one goes to paragraph, page 3502, we explain that we describe the 3 types of customer orders: the customer immediate orders, conditional orders, and benchmark
Sorry, can
orders. Forgive me, 3502 at the top of the page. We describe the
Sorry,
3
can I just
types
check
of.
I'm in the right bundle?
Oh, It's the supplemental bundle number 3, tab 60.
Tab,
60. Page 3502.
I don't have tab 60.
It comes
My
after
version
something
is
headed
page-
J.
Oh, yeah, it's hidden. Sorry, yeah. 3, yeah, sorry, I've got it.
You got it? Oh, you do.
3502.
2, yes.
Yep.
And you see that it identifies the 3 types of trade that the infringement decision is concerned with: immediate orders, conditional orders, and benchmark orders, and notes that the O'Higgins theory aims to recover damages for all 3. Then paragraph 6, it describes the conduct that constitutes the infringement. Paragraph 8 identifies the class. Paragraph 9, again, alleges causation. It is likely that the damages methodology developed by the O'Higgins PCR experts and explained in section D will lead to a conclusion that every member of the class has suffered some loss, in particular because all will have suffered harm owing to the widened spreads, and notes that even if some may have theoretically benefited from a limited number of on occasions, they would have been likely to have lost on average. Paragraphs 10 and 11 then explain the adverse selection risk and how the cartel harm can be measured. You then go forward in this document. It then explains the market expertise, the documentary evidence, including the data, is summarised. And you see, in response to your Lordship's question, third-party data on 3509, paragraph 18, say it may be that third-party data repositories will also be available, and to the extent that they are, the O'Higgins PCR's experts will make use of them so far as possible. And it notes that they can be carried out even if such third-party data is not available. It then explains the damages methodology in some detail, and it explains how the summarises how the regression analysis will be carried out, the types of spreads that will be measured, the volume of commerce that will be calculated, and the potential adjustments for any pass-on tax and apportionment. Now, just pausing there, perhaps my standards of pleading are just very low, but we say it's very difficult to understand why, even before we get to the document that was served after the hearing, why this material is not already a sufficiently pleaded allegation and explanation of the causal link and of a workable, plausible methodology to assess causation and loss. But if there was any doubt about it, we then have the further document that was produced after the hearing, which you see on on tab 76 of the same bundle, page 4958. And this is in response to the tribunal's request for a straightforward articulation of the causal theory of harm.
At the risk of sounding like a broken record, that deals with cartelists.
Both.
Where's
Deals with both. If you look at it, let me talk you through it. Now, you'll see that in paragraph 5, we explain essentially how the bid-ask spread is the price of the service.
Sorry, where are we?
This is page 4961.
So my question was reference to the document you just finished.
Oh, I'm so sorry.
Sorry.
I'm always behind
The document, well, no, I'm always behind you, that's the
No.
problem. The damages methodology section that you took us through, which
Yes.
you said was there,
Yes.
and I was just checking my understanding of it, that it focuses on the cartelists side of things. It
Yes.
doesn't actually deal with the extra bit that I've
The
been
extrapolation.
gnawing it away like a dog
Yes.
with a bone,
No,
which
no.
is the
That,
extrapolation.
I need to check whether it mentions extrapolation, but it is made very clear in the expert reports that an extrapolation
Okay, that's fine.
process
Yeah.
I may need to give you a reference in due course to Breeden's subsequent report. Sorry, he goes into this in a little more detail.
Just to be clear, the extrapolation to the other 55% of the market
Yes.
is based upon an assumption that the other 55%, at least to some degree, is following the price leadership of the 45%. This is the umbrella, I think.
They're going to be charging spreads that are at least as wide as the.
So to some degree, there is supra-competitive pricing across 100%. You may have to make adjustments because it may not be total.
Yes.
But it's the what they used to call barometric pricing. It all generally rises.
It's a rising tide that raises all the boats. Yes.
Yeah. And if that extrapolation, if that assumption is false, of course you can't extrapolate, but you can then adjust.
That's great. So, just if I may, just talk you through this document. Paragraph 5, page 4961, we identify the price. Paragraph 6, we identify different segments of the market. I've discussed the customer-dealer segment and the inter-dealer segment, and we seek to explain how they interrelate, as I've sort of explained. We then, over the page 4963, we explain the competitive structure of the market. We say that this is not a perfectly competitive market, it's imperfectly competitive, and we express that it's relatively concentrated, between approximately 40. These banks alone just having 45%. We then explain in the next section the importance of information asymmetry in the market. We then, from paragraph 12, we describe the collusion described in the decisions, and then we've sought to break the causal mechanism like ancient Gaul into 3 parts. First, we talk about the effect, or in the interdealer segment, the higher costs that are imposed on the non-respondent dealers. And if you look at paragraph 13, this deals with, I think, one of the criticisms that is made, one of the main criticisms that I identified earlier, which is it was said, well, you never say how this higher cost on the non-respondent dealers would manifest itself. And the answer is we do. If you look at the second sentence of paragraph 13, we say the corresponding increase in adverse selection costs would have been experienced by non-cartelist dealers during the cartel period in the form of a higher rate and or extent of loss-making trades suffered by non-cartelist dealers in the inter-dealer segment. Put simply, as a result of the cartels, a non-cartelist ran a greater risk of making a bad bargain. And we explain that this is, by reference to Professor Bernheim's typology, this is a way of making your rivals face higher costs. Because going into that inter-dealer market is a form of, is a cost of doing business. And if, even if it's 1 in 10 trades that you're stunned, it's still going to be a higher cost, which you have to recoup some way. And that then leads us to the second part of the causal mechanism, which is starts at the top of 4968. We talk about the consequential effect on spreads in the dealer to customer segment. And
It's paragraph 16.
yes, indeed. And you see the quote, the quite a neat quote from an academic article. It says this: if dealers set their spreads to reflect only their normal costs of doing business, their losses to well-informed traders would eventually force them out of business. Dealers must widen their spreads further to cover their losses to informed traders. This additional widening of the spread is the adverse selection spread component. It allows dealers to recoup from uninformed traders what they lose to informed traders. By widening the spread, it also decreases dealer losses to informed traders by ensuring that informed traders trade at less attractive prices. So, exactly what's happening. And then we have the third part of the causal mechanism, which is then, well, okay, you've got the higher cost on the non-colluding dealers, that forces them to widen spreads, but why do the cartelists widen spread? And we acknowledge in paragraph 20 that theoretically there are two possibilities. One is they could have reduced their own prices, their spreads, or maintained them at the same level and effectively undercut the rivals, or they could have increased their own prices in order to enjoy higher profits. And we then assert a number of reasons why that the first probability is far less probable than the second. And the first is that they are strategic complements. That's because, effectively, because it was explained in by reference to the economic articles. The second is that it is unlikely to have materially reduced the cartel dealers' own variable costs. That's quite interesting. They make the odd profit from this when they trade with the non-cartelists, but they also have to contend with the fact that the non-cartelists widen their own spreads on the inter-dealer segment because they're worried about losing money. So they actually, they net will not actually face necessarily lower variable costs themselves. And then the third reason why we say the cartelists would have raised their own spread is because we say, well, the Commission decision records that there are exchanges between the cartelists of information relating to bid-ask spreads. And you see that in the judgment that this is seized on, as this is some sort of novelty that we've borrowed from Evans, which it absolutely isn't, as I've shown you. It featured in Professor Breeden's very first report. But it is right to say that it features in our theory slightly differently to the Evans theory, because we regard this as an explanation of why the cartelists are likely to widen their own spreads. We don't see it as a plausible, independent, sort of self-standing mechanism. And the reason that we are skeptical about that is because of the low market share of the cartelist dealers, that the spread, we don't think that the manipulation on spreads would be a self-standing, independent cause, but we do say that it is a contributory cause. So those are that's the causal mechanism, and we say it's set out incredibly clearly in exquisite detail. We then go on in this document to explain also the effect of the coordinated trading on the realized spread, which is an adjunct to our theory of harm, which captures these other forms of collusion. And then we conclude and explain that how we intend empirically to test it by reference principally to regression analysis, but also in light of all the chat room spreads and particularly and the inherent plausibilities and an interaction of the two. So just pausing there, we do allege a pleaded causal mechanism. We do make clear that regression analysis and plausibility analysis assessment by reference to the underlying documents will be used to prove causation as well as quantification. We did allege coordination on spreads all along as a contributory causal mechanism, and we do identify the nature of the costs suffered by the non-respondent dealers. Which then brings us to the first two of those points are covered in the document that we've handed up. You'll see the first point on page 1 is the suggestion that the collusion on spreads was new, which is wrong, and we give you the references why it's wrong. The next point, the next 2 pages, 2 to 3, we deal with the allegation that the pleading didn't allege what were the increases in costs to the non-colluding dealers, and we say we did, and I've shown you paragraph 13. It will take the form of losses on trades. When we explain who and on what market those losses are experienced, it's by the non-respondent dealers on the inter-dealer market. And as I've shown you, that was also clear from the reports of Professor Breeden and Bernheim. It's just not clear what the tribunal thinks is absent here. It may be that they think we should have identified at the pleading stage the amount of the losses suffered by the respondent dealers, but that's entirely unreasonable at this stage. It's a matter for evidence, and it may never be necessary to look at what that precise loss, precisely what those losses were. The tribunal then refers to the myth analogy, but not all cases involve myths. And this case is one in which the initial overcharge is at large. Then if you look at the bottom of page 4, the tribunal invokes stellantis, and the allegation that the pleading is the pleading there was theoretical, wholly theoretical, and they seek to draw an analogy with that case. But that, with respect, was and the analogy is just completely, wholly misplaced. The issue in that case was a completely different scenario. I don't need to tell the tribunal, but it was an issue in which a defendant had averred mitigation by offsetting or reducing costs, and it was pleaded by a set of unsupported and counterintuitive inferences. And this court found that the inferences had a complete lack of realism and were counterintuitive. But that same judgment also recognizes the latitude that will be shown to claimants in such cases. And we're concerned here with an egregious cartel in which an infringement has been found. The plausibility of the basic theory by which loss is liable to have been caused, the adverse selection effect, is accepted. It's richly supported by the academic literature, by several experts, and by the circumstances of the case. If we read on in this document, you'll see Romans 6. The tribunal has a number of objections to the passing on of the cost by the non-respondent dealers to the customers in the form of widened spreads. And they seem to have 3 objections. First one is they say, well, it's very difficult to plead with any specificity that an unidentified loss is passed on. Well, if they mean an unquantified loss, we entirely reject that. Almost any indirect claim is going to involve an overcharge, which at the point of pleading, you don't know the precise quantity of it. The myths are really rather exceptional cases. They then say there's a problem in that the costs or losses suffered by the non-respondent dealer, and they say it's nowhere is addressed. They say the question of intra-market competition from other dealers. Well, by that I suppose they mean the cart list dealers. Well, first of all, it's not an objection to a pleading to say that it doesn't deal with every potential defense or argument that might be thrown at it. But secondly, we do deal with that. I mean, I've shown you, it's in paragraphs 7 to 8 of our statement on the causation of loss that I've just taken you to. I explain, first of all, that this isn't a perfectly competitive market. This is quite a reasonably concentrated market. And then at paragraphs 20 to 22, we give a number of reasons why it is likely that the carteless dealers would have widened their spreads.
Well, you showed us. Widen the spreads rather than narrow them.
Yes, exactly. So it's just wrong to say that nowhere is it addressed. It is addressed in the document that indeed they quoted from. Then in Romans 7, the tribunal speculates that even if there was an increased cost, the increased cost may have been absorbed in other ways. Well, that's true in every indirect purchaser case. The direct purchaser may have absorbed the cost. Whether it has or not will have to be tested by regression analysis considered in light of the documentary evidence. And the same applies to the tribunal's points about in what currencies and in what duration the effect would be felt. Again, that's all clarified in the expert evidence. That would be tested by the regressions. Okay. We say in summary, that that there is nothing to any of these objections, and it's a perfectly adequately pleaded and rather detailed claim. And then what's rather unfortunate is if you then, what follows these paragraphs, if you go to the, if you can go back to the judgment, on paragraph 238, on page 371, it's then, we see in paragraph, subparagraph 4, that it's then suggested that we may be seeking to rely on the first manner, they say, in which they articulated that a claim to market-wide harm can be articulated. And that you need to go back to 23431 for that. That you may recall, it's where they suggest that you could effectively get some disclosure and run some regressions in advance and then plead it by reference to a statistical correlation. It's absolutely clear from our submissions from paragraph 28 that we were suggesting nothing of the sort. We don't have the data yet. The data is in the possession of the banks, and one is not obliged at this stage to make any applications for specific disclosure in order to test one's case on a sort of partial basis. It's completely misconceived. And then what's then really very unfortunate is what you see thereafter in paragraph 238(5) and 6, where it's effectively where various epithets are thrown in our direction. It said that this is just a claim, this is a plea where there's a hope that something will come out in the wash. It said that it's not. This is proceeding on a wing and a prayer.
But if the two professors are right, disclosure from the cartelist banks will either make good or not make
Yes.
good. Their theory.
Yes.
But, that disclosure is yet to be provided. It's clearly disclosure that would have to be provided.
Indeed.
It's not within the sort of concept of
Yes.
the corporism at all.
Yes.
You take issue, I assume, with the words freshly articulated case at the end of the file. Because you say it's not a freshly articulated case, you just say it's proving the already articulated case by documents obtained on disclosure.
Documents obtained by disclosure in the ordinary way. And frankly, these are...
What you actually have, it seems to me, one of the reasons I asked the questions about the probative value of the decision
Yes.
is that wasn't taken into account the more fleshed out decision in the judgment,
No.
but it actually acts as a degree of corroboration of economic theory.
Yeah.
So you have the authorities having looked at the actual facts and having had access to the documents,
Yes.
conducting an analysis of the likelihood of that conduct, either intrinsically or de facto causing harm, certainly gains to the cartelists.
Exactly.
But also they contemplate the possibility of harm to the counterparties.
It's a logical corollary. Indeed. My Lord, I have probably another 15 minutes on the procedural error, if that, probably 10 minutes in fact. I don't know if you, are you prepared to? Then I can conclude this evening.
Can you sit on? I can't really sit much beyond 4:30.
I won't be beyond. I don't anticipate being more than 15 minutes. So one will see that those comments on the merits of the claim that have been made in those paragraphs, and I want on that note just to say something about the procedural unfairness that the tribunal's judgment entails, because as you've seen, it's a remarkable feature of these proceedings that none of the defendants applied to strike out the claims on the basis that they were not properly pleaded. None of them put in expert evidence, nor did they even seek further information about the claims and say that they didn't understand the causal theory They wanted better particulars. These are,
forensic reasons for their passivity.
could be, well, these are as well advised and
There's
well
proceedings
resourced.
going on all over the world, and there may be all sorts of reasons why you fight litigation in one jurisdiction in a different way to another.
Possibly, but well, we don't say that the tribunal has got no jurisdiction to consider of its own motion whether claims should be struck out. Clearly it does have jurisdiction, but the exercise of that jurisdiction is extremely rare, and we're certainly not aware of any precedent.
No, I'm struggling to understand this submission. They didn't strike this claim out.
Well, that's a matter, if I may say so, of interpretation.
Well, that's a
They
different
put
point.
an end to it.
Sorry, it's a different point, isn't it? Your procedure, I understood your procedural unfairness is that they decided to essentially to put an end to it by a different aspect of the decision.
That's correct.
It's not that they did actually
That's
strike it
quite
out
right.
when.
But they use the finding that it's apt for strikeout
Yeah,
as a
okay.
basis for that other part of the decision. And we say
Well,
that
the point you're making really is that they went down a route which you wouldn't normally go down. I mean, the tribunal has jurisdiction to go down that route. Pretty unusual to go down it at all, unless one of the defendants is making an application, in which case you'd have been well on notice of that.
yes,
But if the tribunal does decide to go down that route, well,
Yes.
whether it did or not we can debate, of course,
yes,
then you'd expect them to give you appropriate notice that that's what they're going to do.
appropriate notice and details of the allegations. And now the way this arose was there was some. The tribunal clearly had some concerns which it raised in the most general of terms during the hearing. Then after the hearing it writes a letter seeking these articulation of these causal cases. And the defendants then responded to that, and they encouraged the tribunal to strike out of its own motion. And I do want to just show you how we pleaded back to the respondents in relation to that suggestion. If you could go to volume 3, please, of the supplemental bundle, tab 79. And so this is our response to the banks in responding to their response on the causation of harm statement. If you can go to, please, to page 5026. And you'll see, perhaps I could just invite the tribunal to read paragraph 4 on page 5026, which goes over the page to the top, and paragraph 5, which goes to the top of 5028. So we put the tribunal and the respondents indeed on notice of what we said was the proper approach, to give us fair and full details of the nature of the concern so that we could respond to them. Now the tribunal acknowledges the procedural difficulty when it comes to strikeout, and I've shown you the passages where it acknowledges that its concerns were only crystallised in the judgment itself, and that we weren't given a full opportunity to address those concerns. And that's why they don't strike out the claims. And we say simply, well, if it was procedurally unfair would have been procedurally unfair to strike out the claims without giving us an opportunity to address the precise concerns that led to that strikeout. And it was equally procedurally unfair to end these claims by refusing to certify them on an opt-out basis. And elementary principles of fairness mean that if the tribunal developed these detailed concerns about causality, then the proper procedure was to notify us of the precise nature of those concerns in writing, of its intention to strike out the pleading of its own motion, and to give us an opportunity to make submissions, to make amendments if we thought necessary. And then only following a further hearing, might it then be appropriate for it to decide either to strike out or not strike out. And what the tribunal should not have done, in our respectful submission, is to go to judgment on these points with these trenchant comments without first giving us an opportunity to answer them, still less to then rely on them as a basis to stymie the claim. We do say that that is a further error here, and one that vitiates the findings, and also in our submission has another implication, which is that a fair-minded observer would suppose that there is now a real possibility of bias if the tribunal were to seek to adjudicate the merits of this claim. And that is because the tribunal has stigmatized the claim by denigrating it as weak, in fact both claims, which was not, in our respectful submission, a fair or proper approach. My lords, those are our submissions. And unless you have any questions.
Thank you very much, Mr. Chancellor. Have you got any questions? No, thank you very much. Right, well, we'll adjourn for the day, 10:30 tomorrow morning.
All rise.